and I'll just take the opportunity to reiterate the three pillars, and I hope I do it justice by not plagiarizing it entirely, but doing my best to reiterate that the three pillars were the rules need to make sure to keep pace with modern developments, the processes to ensure those rules are put into effective practice, and there's a need to ensure the independence of those charged with regulating, because I think that's quite a good basis for everything that's to come for the remainder of the day. And so we move on to our second session, which is about lessons learned from major racing integrity cases. And this session will examine the lessons learned from those cases over the past few years. We'll hear from people who investigated these matters and those who prosecuted the perpetrators, illustrating why racing must continue its full commitment to upholding the highest integrity standards. It will comprise short presentations followed by a panel discussion and a Q&A session. The list of speakers, 5 of them, we will do the first 4 speakers, and then we will pause in about an hour's time for lunch, and we'll complete our speakers just after that. But we have today speaking on this subject Mark Van Gestel from the Hong Kong Jockey Club, Cleaner Guy from the Irish Horse Racing Regulatory Board, Jamie Steer from Racing Victoria, Brant Dunshay from the British Horse Racing Authority, and Andrew Adams from Steptoe LLP. First of all, please welcome Mark Van Gestel.
Okay, thank you to Rishi for that introduction, and thank you to the Executive Council for providing me with this opportunity to speak today. The case that I'm going to be presenting is not from my time in Hong Kong, but from my previous employment as a Deputy Chairman and Chairman of Stewards in Sydney. And it really is an investigation that was opened after the running of a race, the 2015 listed Gosford Gold Cup, which was run at Gosford Racecourse in Australia. And here are the concluding stages of that race.
Midsummer Sun goes for home, looking to go back to back at the 150. 2 lengths in front of Fraser's in hot pursuit from Gallatin, then a wall including Multilateral. Midsummer Sun, 75 metres to go, is 2 lengths clear and holding on to win it again. Midsummer Sun from a photo, Fraser's or Oriental Lady. Then for 4th, anybody's guess, Gallatin, Pelicano, Multilateral. They were followed by Fraser's, who pulls up quickly from Blazing Dragon, Ghost Protocol, Casino, Dancer and Hoi Lonnie.
So, as the call identifies, the race was won by a horse called Midsummer Sun, and it was for the second year in a row that that particular horse had won that race. And watching that race as an experienced steward at the time, the race really did appear to be run without incident. It was won by the favourite, it was well supported and well credentialed to win, and Racing New South Wales had robust integrity systems in place at the time, including a stable compliance team where horses were inspected on race morning. And it wasn't really until several weeks later when the racing laboratory reported an irregularity to the sample, firstly to caffeine and then to cobalt, that we were to learn that Midsummer Sun had in fact been drenched on race morning and also injected on race morning. And in fact, these 9 horses finishing behind Midsummer Sun were not competing on a level playing field. So what I plan to do during today's presentation is to detail the events that unfolded after this race, highlight the complexity of this case, which is the need for racing to have robust integrity models, and also which including comprehensive investigative methods, along with rules and processes to empower organisations to prosecute those that disregard the rules and to protect the industry from legal challenges to ensure the highest level of integrity in our sport. As you can see from the headlines, none of which really painted racing in a good light, the inquiry was far-reaching and impacted upon many people's lives. Initially, what was a routine investigation into an irregularity to caffeine quickly escalated into a multi-state case involving cobalt and numerous other serious breaches of the rules being proven. And therefore, it was important that the case was thoroughly investigated. Before taking you through the case in more focus, I just wish to explain the New South Wales disciplinary process that was in place at the time. The stewards are empowered to investigate, to conduct inquiries, issue and determine charges, and also issue penalties. Any person aggrieved by a decision of the stewards then can appeal to the Racing New South Wales Appeal Panel, which is a a body legislated through the Thoroughbred Racing Act, and from there the second level of appeal is the Racing Appeals Tribunal, which is legislated for by the Racing Appeals Tribunal Act. And any further contest from there goes to the courts, and obviously starting with the New South Wales Supreme Court. A quick summary of the action taken by the stewards prior to the matters being finalised at appeal. There was 59 individual charges issued by the stewards. 8 persons were disqualified in New South Wales, including the trainer, 2 interstate vets, the trainer's foreman, a harness trainer, an official, and even a number of unlicensed persons. And a total of 31 years of disqualification were issued by the stewards. And also the investigation identified that 7 horses had in fact been treated in breach of the rules of racing on 10 separate occasions on race day. Some of the major breaches that were charged included the administration and presenting of a horse to race with cobalt and caffeine in their system and to affect the horse's performance, the injecting and treating of horses on race day, the IV administration and supply of substances that were prohibited at all times, including substances cobalt and xenon, persons giving and persuading to give false evidence, and also people providing inside information, and finally conduct prejudicial to the image of racing. And they were really the major charges that were issued as a result of that particular investigation. The appeal and legal challenges, in respect to that, there were 5 persons that appealed to the first level, the Racing New South Wales Appeals Panel. There were 2 further appeals to the Racing Appeals Tribunal. One, in fact, was an appeal by Racing New South Wales. And also from there, 2 persons lodged application for judicial review to the Supreme Court of New South Wales. So how were these breaches detected? Well, firstly, and obviously, robust anti-doping controls that were in place, and the racing laboratories keeping abreast of new substances that were on the horizon. And this case was really assisted by the early notification of the racing laboratory to allow the investigation to commence quickly. The stable search was an important element of the investigation and the seizing of substances and exhibits. And it's important to have rules to allow stable searches to be conducted, to the taking and possession of exhibits. And those inspections need to be unannounced searches, and they need to be thorough. And this particular occasion, the trainer was living above the stable premises and identified a bottle of cobalt hidden in a kitchen cupboard that contained cobalt at a concentration of 175 times the registered products containing cobalt. And without that search being thorough, the bottle may never have been discovered. The testing of exhibits to complement that seizure, and in this case the laboratory was able to confirm the level of cobalt detected, and having protocols for chain of custody is extremely important to avoid challenges in respect to the collection, transportation and analysis of the samples. The imaging of mobile telephones and computers was also a very important part of the investigation, and once again important to have rules in place that provide the power to image mobile telephones, where in this case the licensees and veterinarians all agreed to be bound by the rules. And this was a case, on one of the first occasions that I can recall, where mobile phone imaging was used, and the image really did provide a chronological order of messages identifying breaches of the rules. And once again, without that evidence, the breaches may not have been proven. The auditing of financial and business records was also a crucial element of the investigation, and obviously the interviewing of witnesses in this case included a number of vets and stable employees. Probably one of the most crucial processes for this case was the information sharing agreement that was put in place between 2 states, New South Wales and Victoria. And whilst the states do operate under the same Australian rules, they do have different local rules and obtain their powers from their own legislation. And the information shared between the 2 organisations included phone data, exhibits and also analytical results, financial records, and also the transcript of witness interviews. And it was really crucial evidence that both states had in their possession, and once shared assisted in establishing many of the offences. So it is important to ensure that rules and powers allow for information sharing. In relation to the Stewards' inquiry, the composition of the Stewards' panel for this inquiry saw Mr Keith Mason AC, who was the former President of the Court of Appeal of New South Wales, the highest court in New South Wales, being appointed by Racing New South Wales as a co-chair of the inquiry. And his appointment was in response to an official who was penalised in respect to the matter and Mr Mason's appointment gave additional credit and provided more balance to the stewards panel. In addition to that, there was a fresh panel appointed for the hearing of charges against one of the vets, Dr Matthews, to avoid the perception or lack of procedural fairness or natural justice, as Dr Matthews' charges were determined some months after the original stewards panel had determined the charges for the trainer and also some other persons. So it is important to ensure that procedural fairness and the stewards have an open mind when determining charges, and the rules allow such appointments. Whilst there was 8 persons disqualified in total, today I'll focus on 2 of the persons who took their case to the New South Wales Supreme Court, the first of those being trainer Sam Kavanagh and the second vet Dr Adam Matthews, both who sought relief through judicial review through the Supreme Court of New South Wales. And the first of those being Mr Kavanagh, who was found guilty of 20 of the 24 charges issued by the stewards. His total penalty that it was issued by the stewards was 9 years and 3 months, and it was ultimately reduced to a period of 4 years and 5 months after the appeals and judicial reviews. And several breaches, in fact, attracted mandatory minimum penalties, which were introduced in 2013 into the Australian rules, and they were for serious offences and therefore required the stewards to consider special circumstances in relation to these matters. And in this particular instance, the test included, as relevant in this case, of whether the person proves on the balance of probabilities that he ought not know, ought not to have known, or would not have known had he made all reasonable inquiries that his conduct was in breach of the rules of racing. The next slide just outlines the disciplinary process for the Kavanagh proceedings, and I won't take you verbatim through them, but one of the important elements of that particular timeline was the second occasion there where his licence was suspended in the 20th of May 2015. And as you can see, it took some 4 years for the case to be finally resolved, but having that rule in place where the stewards determined that his ongoing participation was prejudicial to the image, to the integrity of racing, and in those circumstances they're able to suspend his licence and stop his participation in the industry to protect the image of the sport. The appeals then to the Racing New South Wales Appeal Panel and also the Racing Appeal Tribunal, the first challenge was really in relation to Rule 175H, which at the time it created an offence if the person administering a prohibited substance was intentionally to affect the performance of the horse. And the challenge was really as to whether he had knowledge that the substance contained a prohibited substance was required. And after the 2 appeals were completed, the panels both found that it was not necessary to establish that the trainer had knowledge and that the substance contained cobalt. The purpose was essentially established through the administration of the unregistered product. And they did have found that the administration was to affect performance, and on that basis, Mr Kavanagh was given a 3-year disqualification for that offence with the mandatory minimum penalty. The second challenge related to whether cobalt was a prohibited substance at all times at high levels, and the panel found it was prohibited at all times when at high levels as defined by the rules, and it highlighted the importance of having expert evidence. Without that expert evidence, that particular offence may not have been proven. And after being found guilty, a 2-year mandatory minimum penalty was issued by the panel, and he was given an 11% reduction by the Racing Appeals Tribunal for special circumstances, which I just dealt with. This then resulted to judicial review to the Supreme Court, and the 4 grounds were essentially that firstly the tribunal had erred in the construction of 175H, and that knowledge or belief of the prohibited substance was not required, and the Supreme Court quashed the decision of the tribunal. Secondly, the second ground of appeal, it was also found that the tribunal had erred in his construction of 196, which related to special circumstances, and he was given an inadequate reduction in penalty, and as a result that was remitted back to the tribunal. The third grounds was in relation to affording procedural fairness and as to whether the tribunal had failed to provide a Parker warning to the appellant in relation to the intention to increase the penalty. And the fourth grounds was whether, and the final challenge was whether the appeal panel, the tribunal, also the stewards had committed jurisdictional error, imposing penalties when they were not empowered to do so, absent from a delegation of Racing New South Wales. And in that particular ground, the court found in the favour of Racing New South Wales that all were empowered to determine breaches and penalties imposed. So It's important that with those grounds that there was no challenge in relation to how the evidence was collected or gathered, how the inquiry was conducted, or how the stewards panel was in fact constituted. So that then resulted in the penalty of 9 years and 3 months then being reduced to 4 years and 5 months after judicial review. The second person who challenged was Dr. Adam Matthews, and Dr. Matthews also sought judicial review through the Supreme Court, and he was charged and found guilty of 6 offences by the stewards, charge 1 being a party to a breach of race day administrations, and charges 2 to 6 being that he was the supplier of the vitamin complex bottle. And for that, the stewards issued a penalty of 5 years and 6 months. Once again, the proceedings, you can see, commenced in 2015 and didn't complete until 2022. And that was essentially due to a number of factors, Dr. Matthews not being available, but also due to the case involving Mr. Kavanagh going through judicial review. In respect to the appeal panel, firstly, he was found guilty of charge 1, being a party to the race day administrations, but then charges 2 to 6 he was found not guilty of, and essentially what the tribunal had said, that they had the evidence of 2 vets. 1 vet was telling the truth and one of them was lying, and the panel, I should say, was not comfortably satisfied that with actual persuasion that Dr. Matthews had in fact supplied the vitamin complex, and for that reason he was found not guilty of charges 2 to 6 and given a 6-month disqualification on charge 1. That then resulted in Racing New South Wales lodging an appeal to the Racing Appeals Tribunal, and that appeal was heard after judicial review of Mr. Kavanagh, and it resulted in Racing New South Wales amending the charge to remove the effect performance portion of the charge. And the tribunal said, when considering the Brigginshaw standard, that actual persuasion must not come from inexact proofs, indefinite testimony, or indirect inferences. And the Racing New South Wales case really did rely upon the credit of Dr. Matthews, but also relied upon 2 crucial witnesses, Dr. Tom Brennan, who was his practice counterpart, and also the trainer, Mr. Kavanagh. And the tribunal was satisfied on appeal from Racing New South Wales that Dr. Matthews had in fact supplied the vitamin complex bottle. This then resulted in judicial review to the New South Wales Supreme Court by Dr. Matthews, and there was 13 grounds for judicial review. Jurisdictional error and error of law in the face of the record. The tribunal had erred in its construction of the Australian rules of racing, and findings of fact is not open on the evidence, and no evidence to support the finding. All grounds were rejected by the court, and once again, no challenges in relation to how the evidence was gathered or the inquiry was conducted or the panel constituted. That then resulted in the final penalty being issued to Dr. Matthews, initially 5 years and 6 months, being reduced to 1 year. And that was principally due to the removal of the effect performance criteria of the charge, but also there was found to be a number of commonalities amongst the other charges, and ultimately Dr. Matthews served a 1-year disqualification. So whilst in this case the headline charge of administering a substance to affect the performance was not proven, it did provide a valuable precedent, which was found by both the New South Wales and Supreme Courts, that to establish the administration of a prohibited substance to affect performance, the person charged must have knowledge of the prohibited substance being administered. And the key takeaways or the important insights from this particular case really were that race day sampling and inspections should always be unpredictable. When conducting an investigation, always think long term, ensure that your processes are watertight, and expect a legal challenge. Working with other jurisdictions can be extremely beneficial, and in this particular case, I would expect that many of the charges would not have been proven without the 2 states working together. Having rules in place to allow for searches and mobile phone imaging, evidence gathering. We've heard earlier today the importance of making sure that rules are current and up to date, and as technology changes, we should adjust our rules to meet those new changes. To ensure that the proper delegations and powers exist for stewards to exercise powers under the rules, and the appointment of stewards to avoid any bias or perceived bias, and once again to avoid any legal challenges. And the need then also to secure experts to give evidence at inquiries, and without having expert evidence, many of those charges that were brought against the persons disqualified may not have been proven. So they're really my insights into the case. I hope that you've gained some valuable insights into that particular matter, and we look forward to the discussions later on today.
Yes, indeed, Mark. Thank you very much. We'll be looking forward to chatting to you a little bit later on. But now, please welcome Cleaner Guy, Head of Governance and Legal, Irish Horse Racing Regulatory Board.
Morning, everybody. Thank you very much for the opportunity to present on IHRB cases, and specifically the case involving the presence of 2 anabolic steroids in hair samples taken from a horse. I suppose from lessons learned was my running orders for this presentation. I wanted to start to give everybody an understanding of the IHRB integrity processes and what we deal with on an annual basis. So in terms of our integrity matters, and just giving the figures for the last 3 years, you can see there that our stewards on an annual basis are dealing with in excess of 800 inquiries. Now that would be over 500 inquiries per annum and a number of reports. Our referrals have been within 67, 56 in 2021, that was COVID impacted. And then our appeals, as you'll see, haven't been, or in around 50% of our cases have had appeals. Of our runners, we are sampling in between, we have 38,000 runners in 2023, with a total of 5,866 samples taken between race day and out of competition testing. And in around 6% of those have returned in adverse analytical findings. In between those day-to-day work, and I know those of us who are involved in integrity appreciate how much cases take. It can look very simple sometimes, but we're akin to the duck paddling furiously under the water. In 2021, we had a case involving a trainer, Luke Comer. And to give you an idea of this case, I wanted to put it into figures first, because sometimes figures speak very clearly. In this case, we had over 142 samples analysed. That was hair, blood, urine, and a proprietary altrenologist was also analysed. We had 14 days of hearings, including case management hearings. I have excluded there a licensing committee hearing as well, so 14 days of hearing, you can imagine the preparation that involves. In this case, we had counsel on both sides, both senior and junior, and we had in excess of 6 solicitors involved. In terms of our booklets, 182 booklets were prepared for the referral, and 183 booklets were prepared for the appeal case. And then we had in excess of 16 expert witnesses. I say in excess, we're talking 16 were the external witnesses instructed. And going on Mark's very interesting presentation before me, we secured our experts early. We also had the expertise, our internal expertise, including Dr. Lynn Hillier, who also gave significant evidence and also led the investigation process. To give you an understanding of the case, for those of you who didn't live it for 3 years and deal with it on a daily basis, He Knows No Fear ran in Leopardstown on the 16th of October 2021, and race day stewards, under their powers and the rules, ordered samples to be taken from him. A hair and urine sample were taken. On the 2nd of November 2021, LGC Laboratories notified us of a screening finding for 2 androgenic anabolic steroids, methandinone and methyltestosterone. These were confirmed on the 10th of November 2021, which was then followed by a joint inspection on the same day by our officials and by officials from the Department of Agriculture, Food and Marine, who are our parent department in Ireland. On that day, our officials took over 123 samples, mainly hair, but also blood samples taken. And of those samples, we had 12 horses, including the original case horse, return an adverse analytical finding for the anabolic steroids. Following on from that, we had a B sample confirmation process, and these were carried out by both LGC and LCH. And again, my gratitude to both laboratories for the extensive work and support they provided in this case. We did seek to have these licenses suspended by the licensing committee, and again, touching back on Justice Clark's presentation, our rules have not kept pace with processes and with modern requirements. So our licensing committee unfortunately found they did not have the power to impose the sanction that we were seeking, or not even a sanction, to propose the condition that we were seeking. So we were unsuccessful in that application. However, we did have a voluntary undertaking from the trainer not to run any of the horses which had an adverse analytical finding. This case was unusual in the trainer was also the owner of all equines involved in the case. We did not have any external owners or external owners involved. As I mentioned, we had expert witnesses who were engaged to provide the reports, which contributed extensively to the 182 booklets. We had a large number of reference papers. Thankfully, we had the scientific minds to read that and summarise it for the legal minds, who are not always adept at understanding the various picograms and nanograms and other aspects that come in with these anti-doping cases. And we received reports from over 11 experts on behalf of the trainer. We did go to case management hearings. Majority of our cases in Ireland are dealt with within 90 minutes to 2.5 hours. That is majority of our cases, and I'd say I'm probably speaking the same for the majority of our racing authorities. As you saw, this ran to, the first hearing was 9 days long. In order to get to that stage where we were ready to have the hearing, we required case management hearings to ensure we had pleadings exchanged, we had our expert reports in order, that we were not going to start on the day and then discover the needle in the haystack. Notwithstanding those case management hearings, we were on notice of full proof of our processes, of our chain and custody, of our sampling processes until the morning of the first day of the hearing, when the positive find or the adverse analytical finding was accepted by the trainer. So we had prepared for our case on the basis of going through full proof. I think we had in excess of 20 witnesses that we were prepared to call to go through all the process. Luckily, we didn't have to continue with that. However, it did mean our case and our counsel had to change tack immediately and proceed on that basis, which again, Ron Kennedy, Senior Counsel, and Quiva Daly, Jr., did an amazing job with that and being told to change tack as they were lining up to start. As I said, the referral was over 9 days in May 2023, and the decisions were issued and further submissions were made on sanctions. So the committee made a decision on the breaches and then sought submissions on sanctions from both parties. The final decision was issued in around September 2023. Apologies. So on the decision in 13th September 2023, the trainer was found in breach of Rule 96 regarding the presence of prohibited at all times substances in the horses and having brought the sport into disrepute. There was fines totalling €60,000, a withdrawal of licence for a period of 3 years in respect of the anti-doping breaches, fines totalling €25,000 and a concurrent 3-year withdrawal of licence in respect of the dispute charge, and 80% of the costs of the IHRB were awarded to the IHRB. The decision was appealed, and the trainer appealed it on 37 points. They are set out in the appeal decision, which is available on our website if anybody would like to go through that. I have not listed them in the slides. I was only given 15 minutes. We appealed on the grounds of undue leniency. And we moved to the appeals body hearing in May 2024. At the appeals body held following a 3-day hearing that the appeal of both the findings and penalties imposed in respect to the breaches of rules 96A, B and C, so they are the findings of prohibited substances in the samples, were dismissed, and the trainer's license was withdrawn from the 15th of July 2024 for a period of 3 years. The appeal of the breach of Rule 272, which is the bringing of the sport into disrepute by action or conduct, was dismissed, but the penalty was set aside. The appeal of the breach of Rule 272 was allowed and the finding and penalty set aside, and 272 is provision of misleading information. And then the IHRB appeal in respect of undue leniency of penalty was dismissed. Similar to Mark's presentation, there is a lot of learnings we have taken from this case. It was the first of its kind for us in terms of the size and the extent. The 120 samples had to be analysed, created quite a significant workload for our labs and trying to manage that information and getting it back. One of the main learnings I've taken from it, and I think Mark touched on it earlier, is having a team in place early with clear roles. Once we had the screening finding for the sample in the hair, we instructed counsel. Hair matrix is not one that has been used extensively in prosecution of anti-doping hearings, and it was challenged. It was one of the main challenges in the referral hearing in relation to that use of matrix. Was it a reliable matrix? Was it a recognised matrix that we could base a prosecution on? And where we really relied on our international colleagues and our international institutions was in dealing with that challenge, among others. We referred to the ARC best practice documents and IFHA documents and agreement, the international agreement, to show that this was not rules and this was not a process that we had created ourselves. This was following in line with international practice. And that benefited us in our cases and helped us to deal with the challenges. In terms of the investigation, it was led by an experienced and highly informed veterinary team who are not only regulatory vets, they are on track day in, day out. They are seeing the horses, they are in practice as well, but they understand what they should be seeing and how they deal with it. They are taking samples on a regular basis. We sent a team in who took 120 samples in the course of a day, and that allowed us to carry on with our investigation and ensure that we weren't dealing with one horse returning an adverse analytical finding, we were dealing with something bigger. Part of the challenge to the case, or the explanation offered by the trainer, was the adverse analytical finding had arisen from the contamination of hay through the use of silage which had been gathered from pigs who had possibly ingested a contaminated product. We did analyse a proprietary alternatist product to see had there been an issue with contamination which may give rise to this adverse analytical findings. We were also able to tap into our international network and ask, had anybody seen a rise in screening findings in relation to these substances, which had not occurred, or had anyone seen or heard of an issue in relation to contamination of products which may be available on the market, which also could have been an issue. Under our rules, under Rule 1481, the trainer is obliged to provide a satisfactory explanation, and that can be taken into account by the disciplinary body. While the onus is on the trainer, it's a strict liability offence, we investigated to the fullness of our powers as part of our uncompromising attitude to integrity, to ensure that we could answer as best we could what we were dealing with and understand it. Only by understanding what we're dealing with could we ensure that there was a fair and proportionate process and, in the end, sanction imposed. We also had use of the Advisory Council in addressing some of the unique aspects of the case, including hair as a primary matrix. We were fortunate that some colleagues of Dr. Hillier was able to provide us with information regarding previous cases that had been taken using hair as a primary matrix. The need to review and test rules and procedures on a regular basis. This has led or was part of the drive to our rule review project. I sometimes refer to a rule book as Frankenstein's monster. It has been patched and put together at various stages, and when you sit back and look through it, and also with the benefit of cases, it allows you to ensure that your rule book is adaptable and also appropriate for the cases you are dealing with and as things change. This case had a closer similarity to a High Court proceedings as opposed to a disciplinary hearing in a sports body, but yet we had to deal with it in the same way, but ensure we had protected ourselves and we could stand over every decision we made if we were legally challenged. We were very lucky in Ireland that we have access to experienced legal chairs. This case was one of the first where we brought in an independent chair to sit at the first instance basis. And we had a retired High Court judge, Justice Brian McGovern, who led the panel and dealt with the 9 days of hearing. To have a layperson chairing a panel involving dealing with two senior counsels, I don't think would be fair or appropriate. And we were very lucky to have access to Justice McGovern. And at the appeal process, we had Justice Peter Kelly, former High Court judge and former chair of the Commercial Court, who dealt with the matter brilliantly and produced a very, very good, clear, effective decision. And our experienced panel members, while it's fabulous to have access to the legal minds who can manage the hearing and ensure that you have a bit more security when it comes to the legal process, you do need experienced disciplinary panel members who understand racing, who understand what they're dealing with and have an appreciation of what is appropriate and what is right within the industry. And across the panel, we had 4 panel members who sat and gave of their time voluntary and gave of their dedication to it and understood and gave the very good, contributed to the decision which resulted in our final case. So I have to say thank you to all our team. I'm one person presenting on a case that involved a large number of a very small team, and they worked very hard to ensure we got the outcome. As all of us would know, we're perfectionists as regulators. You sometimes would have hoped for a different decision, but we got a withdrawal of sanction. We had an approval of HARE as a matrix for anti-doping prosecution, and we managed to deal with the case in an effective, robust, transparent manner. I think that was a success for all of us. So thank you very much to everybody.
Cleaner, thank you very much. Our penultimate speaker before lunch is going to be Jamie Steer, the Executive General Manager, Integrity Services, Racing Victoria.
Thanks, Rishi, and thank you to the IFHA for giving me this opportunity to walk you through at a high level what I believe to be an interesting case in integrity in Racing Victoria. I hope this presentation will provide you, as administrators and regulators, with considerations and opportunities to support your integrity departments as they undertake complex investigations, often in the face of adverse public commentary. Beg your pardon. The origins of this case I'm going to walk you through arose from the execution of a court-granted search warrant on premises of a licensed thoroughbred trainer by members of the Sporting Intelligence Integrity Unit, a unit of the Victoria Police Force. The warrant executed was part of a far-reaching investigation involving several participants licensed by Racing Victoria, with there still being some ongoing disciplinary proceedings in relation to the broader investigation. I will limit my presentation to the narrow matter of dealing with the banned at all time substances, erythropoietin, which for all our sakes, most particularly mine, I shall hereinafter refer to as EPO. On 30 January 2019, a search of private residence of a trainer was carried out by the police under the previously mentioned warrant. They asked members of the Racing Victoria Stipendiary Stewards panel to be available to assist in identifying the relevance of seized items so far as the rules of racing are concerned. During that search, 6 preset syringes labelled EPREX 10,000 were seized from a bedside drawer in the main bedroom of the trainer's house. The expiry date on those syringes was October 2007. On the 1st of February 2019, all items seized under the warrant, including the syringes, were produced to a magistrate who authorised Victoria Police to conduct analysis of the syringes. As the Victorian Police Forensic Scientific Science Centre advised they did not have the capability to test the syringes, they were lodged with Racing Analytical Services, RASL, an approved racing laboratory. RASL was asked to analyse the syringes for EPO and whether or not there was any evidence that they had been used on an animal. On 27 February 2019, the laboratory confirmed the syringes contained equine blood, but they were not in a position to be able to certify which horse the blood originated from. The syringes were therefore transferred to Racing Australia's Equine Genetics Research Centre on 2nd of April 2019 for DNA analysis. DNA analysis of the blood found in the syringes. Their task was to extract and analyse the DNA present to identify the horse from which it originated. To do this, they need to collaborate with the Australian Stud Book, which holds DNA profiles and samples from all thoroughbreds that have been DNA typed in Australia for the purpose of parentage verification. In my layperson's explanation, the Research Centre, after doing preliminary workups, originally identified 3 markers, which, with further work, extended to 12 markers. Using this information and some other further work, a search of the whole Studbook database was conducted to identify horses which had profiles that matched the markers. This identified a single horse, Cat's Fun, which was a perfect match for all markers. As this was the first time this type of search had been done by the Research Centre, and to ensure the result was not a false positive, a check was run against the 2003 sample submitted to validate the parentage of Cat's Fun. All markers were found to be 100% in concordance. On the 14th of June, the police received from RASL the results of analysis for EPO, which was confirmed in 2 of the syringes. Then, on 15 August, the police received confirmation from the Research Centre that they had identified that the blood present had originated from a horse, which was the registered racehorse Cat's Fun. The trainer from whose house the syringes were seized was the registered trainer of Cat's Fun for 2 periods between 1 July 2009 and 27 October 2014, which was the day of the horse's last race start and the day on which it was retired. You may have noted that the commencement of those dates is some 2 years after the expiry date on the syringes. On 20 August, the police wrote to me enclosing information about the syringes and their contents. On the basis, offences may have been committed against the rules of racing involving the trainer. They said, the attached information is provided to Racing Victoria for the steward's assessment. The information provided is law enforcement data and disclosed under Information Privacy Principle 2.11 under the Privacy and Data Protection Act of 2014. In relation to any unlawful activity relating to breaches of the rules of racing, Victoria Police are not progressing criminal charges in relation to this information, and that concluded the letter. From there, on 26 August 2019, the stewards advised the trainer that they had opened an inquiry under the rules of racing into the information referred by the police. When the stewards commenced their interview with the trainer, there was no explanation offered due to the trainer's legal representative blocking lines of questioning based on the admissibility of evidence from Victoria Police. Therefore, the inquiry was adjourned. Having considered this, on the 2nd of September, the stewards notified the trainer they had formed the view that there were reasonable grounds to suspect he had committed breaches of various rules of racing, and that they intended to lay charges for the breach of those rules. He was required to show cause why he ought not be suspended with immediate effect, pending the hearing and determination of any charges that were to be laid. On the same day as receiving that notification from the stewards, the trainer filed an urgent application with the Supreme Court against Racing Victoria and the State of Victoria, or in essence, Victoria Police. The application sought orders restraining Victoria Police from providing Racing Victoria with information related to items seized under warrant from the trainer's property on 30 January 2019, and restraining Racing Victoria from relying on that information it had already received under cover letter from Victoria Police related to some items seized under warrant for the purposes of a steward's inquiry or any other disciplinary proceedings. The Supreme Court hearing of the application for relief the next day, the stewards gave an undertaking that they would not proceed to take any action based on reliance on the information provided to them by the police until the hearing and determination of the matters before the court. The substantive Supreme Court hearing took place on 25 September. In that hearing, the trainer submitted that the information obtained as a consequence of the exercise of a coercive power by the police could only be used for the purpose for which the power was conferred and not otherwise. He also argued that police had a positive duty of confidentiality in relation to the items seized under warrant, and that duty also applied to any information derived from those items. The trainer submitted that the only use that could lawfully be made of the information derived from those things seized under warrant was for the investigation and prosecution of indictable offences. The Supreme Court held that evidence of observations made during the execution of a warrant under the relevant section of the Crimes Act or information derived from those things seized under warrant are not subject to any limitation or duty of implied confidentiality. The court did say that although the police were not free to disclose the information to the world at large, they could use and disclose the information for limited purposes defined by common law and legislation. The court also found that the disclosure of the information by the police to Racing Victoria was authorised by the information privacy principles because the police had reason to suspect that unlawful activity had been, was being, or may be engaged in, and that they used or disclosed the personal information as a necessary part of its investigation of the matter or in reporting its concerns to the relevant persons or authorities. The court heard that unlawful activity is not limited to criminal activity and instead encompasses any activity contrary to the rules and laws, whether criminal or civil, and that any organisation to which the Privacy and Data Protection Act applies may investigate the suspected unlawful activity itself or refer its concerns to a relevant person or authority. As a result, on 18 October, the court ordered the proceeding be dismissed. On 30 October, the stewards issued 2 charges against the trainer. The first related to the administration of EPO to Cats Fund for the purpose of affecting its performance in a race. The second related to possession of a prohibited substance. These charges were filed with the Victorian Racing Tribunal, an independent body responsible for hearing racing-related disciplinary cases which are classified as serious offences. On 13 November, the trainer filed application to the Court of Appeal to the Supreme Court decision. The Court of Appeal hearing took place on 22nd July 2020. with the decision being delivered on 10 September. The court affirmed that the police's duty of confidentiality did not extend to information derived from the seized items. The court also found that disclosure of this information to Racing Victoria was authorised under the relevant information privacy principles. The court upheld the Supreme Court's decision that the relevant section of the Crimes Act does not impose a separate or concurrent limitation on the use of information derived from the execution of a search warrant. The court held the Supreme Court was correct to conclude that contravention of the rules of racing was unlawful activity for the purposes of the relevant information privacy principle, and that Racing Victoria was a relevant authority. This is because Racing Victoria regulates the rules of racing in accordance with the Racing Act of 1958, which prescribes standards and obligations and provides for investigations and determinations of breaches of the rules. Racing Victoria can also issue sanctions. The court found that the rules of racing are directed at identifying norms, the breaches of which are unlawful, and confirmed the Supreme Court's view that unlawful activity extends beyond criminal conduct. The trainer was unsuccessful in his appeal and it was dismissed. That is a very significant finding, not just for racing, but for all sports. On 5 February, the Victorian Racing Tribunal heard the charges which have been laid against the trainer by the stewards. At this hearing, the trainer pleaded guilty to both charges without offering an explanation for the use of EPO, and the hearing immediately progressed to submissions on penalty. On 22nd February, the tribunal handed down their decision, which was a penalty of disqualification for 3 years. So, what are the learnings from this case? Firstly, I would urge you to work collaboratively with external agencies, such as the police, wherever the opportunity exists, and encourage them to avail themselves of the various tools racing has in its armoury to establish wrongdoing in our sport. Secondly, provided you have followed procedures correctly and in accordance with the relevant laws, you have nothing to fear from the courts. Thirdly, you do not require a certificate of analysis showing a sample from a horse contains a prohibited substance to proceed with a disciplinary case of this type. You just need to be able to join the dots in a logical sense to establish that an administration occurred. And lastly, it is important that participants and punters have confidence in that integrity matters will be followed through to protect the good of our sport, no matter when they occurred. Thank you.
Jamie, thank you. We have one more speaker before lunch, so we'd like to welcome Brant Dunshay, the Chief Regulatory Officer of the British Horse Racing Authority.
Thank you, Rishi, and thank you to my learned colleagues who have now left me with 1 minute till the lunch break. So I'll try and keep it relatively brief. The last 3 presentations you've heard about have related to the anti-doping related matters. And whilst I am chair of the EHSLC, which is Europe's anti-doping committee, today I'm going to talk about a betting related corruption case. Which is a little different to the presentations we've just heard about. First of all, just a brief background on the British Horse Racing Authority. For those that don't know me, I'm the Chief Regulatory Officer of the British Horse Racing Authority, and I have overall responsibility for the integrity functions of British racing, both on and off the racecourse. In Britain, it's a busy racing environment. We conduct around 1,500 fixtures per year, and on some of our busiest days, we'll actually run 8 fixtures on those days, particularly during the summer. Servicing that volume of racing and ensuring that we protect the integrity of our racing product for our participants and, importantly, our consumers which is fundamentally important to the commercial success of our sport, requires the BHA to have in place robust, well-organised and well-resourced operational model that aligns with global best practice. Central to the BHA's business plan and one of our key strategic priorities is to ensure British racing is safe, fair and clean for all participants, both equine and human. Therefore, we must stay ahead of and deal effectively with any new or existing integrity threats to the sport. To do that, our operational model aligns with the best practice examples that are set out in the IFHA's Integrity Handbook. In that context, and to meet our strategic commitment, we have in place a modern race day stewarding model which combines professional contemporary best practice with the best components of our historical stewarding structure. It has at its disposal new technologies which support the race day regulatory functions via the existence of a virtual stewards room, enabling other integrity professionals to tap in real time and contribute to the regulation of the race day. Based on the National Intelligence Model framework used by police forces across Great Britain, we have a standalone intelligence function supported by contemporary intelligence gathering IT systems to assist us in monitoring, tracking and assessing information received regarding integrity threats. To the right on the screen there, you can see an example of how we promote the avenues available to people who wish to inform the BHA of issues of concern or wrongdoing. It's called RaceWise, and it's an anonymous reporting channel for all. We have a team of investigators available to deploy and deal with any potential integrity threat or potential breach of the rules of racing as required, along with, and this is central to today's presentation, an in-house bet monitoring function, tracking every race, every day, capable of updating stewards in real time and investigating suspicious activity on betting markets retrospectively as well. We also have a team of regulatory professionals, lawyers and advisors who assess investigative findings, prepare case briefs and, if appropriate, prosecute breaches of the rules of racing. And importantly, in terms of adherence to global best practice, and it was a pleasure to listen to Justice Clark speak about this very important concept earlier, British racing has an independent judicial panel who consider all serious charges brought against individuals in the first instance, chaired by a respected King's Counsel, and also it acts as a forum for appeals in relation to the steward's decisions on a race day. So the question really is, why are these functions so important to protecting our sport from integrity threats, and how do we deliver this in practice? The case study I'd like to touch on relates to a former British jockey, Danny Brock, and a group of others. And this will emphasise the relevance of how your racing jurisdiction can benefit from the new resource developed by the IFHA, the Integrity Handbook, and the best practices it covers. I'd like to briefly take you through this case, and actually it's a theme that's emerged throughout the presentations. Whilst it was dealt with last year, you'll note that this commenced back in 2018, 2019, and it's taken some time to bring it to a conclusion, a theme that's emerged through all of the cases as a consequence of that more complex legal environment that we all work in. In February and March of 2019, a dispute arose over prize money between participants and racecourses in Great Britain. Sound familiar? And most trainers and jockeys took a decision not to participate in some fixtures. A small number of jockeys and trainer owners, however, continued to participate at the fixtures, the subject of the dispute, with the result being that for a period there were very small field sizes. Jockey Danny Brock was one of those who continued to participate, despite the fact that most of his weighroom colleagues were choosing not to. And on the screen here you can see that he was very public in regard to his reason for doing so. During this period, these jockeys riding at these events were riding for trainers with whom they may not have had long-standing relationships. This is a factor evident in this particular case with regard to some of the races and rides that were scrutinised. So the environment created some unusual scenarios and opportunities, both good and bad, unfortunately, for participants. With this background in mind, on the 7th of March 2019, a race was scheduled at Southall Racecourse over 5 furlongs between 2 horses, Tricky Dicky and Samovar. Effectively, it was a match race. I'll direct your attention to the replay of the race on the screen. The horse in the predominantly green silks is Tricky Dicky. The horse in the predominantly orange silks is Samovar, who has drawn stall 1. At first glance, the casual observer may have formed a view that it was unfortunate that the horse drawn in stall 1, Samovar, had missed the start as a consequence of some wayward behaviour and over the short 5 furlong distance lost all chance. To some of my learned colleagues in the room who are trained observers and race day stewards, they will have observed that in fact there was some delay and difficulty in removing the blind the horse was wearing. There was also an awkward period straight after the start where the horse was taken initially left and then to the right. So there was much more to it than simply waywardness in regard to the horse's behaviour. On the morning of the race, so this is some hours prior to the race day, our bet monitoring function kick into operation, and our race day integrity team leader communicated with stewards his assessment of the 2 runners and the movements in the market, which seemed inconsistent with his own assessment. On the screen you can see a screenshot of our online real-time notification system, which alerts stewards on course. From very early in the day, the betting markets had shifted one way, with the initial favourite Samovar easing from 5 to 4 on to 13 to 8. So this information enables the stewards to pay particular attention to the circumstance of the race as it pans out. You've all seen the replay. Immediately following the race, the stewards receive a further alert via our monitoring team highlighting that Samovar had drifted further and started 2 to 1 in the 2-horse race. Again, you can see here in the screenshot that urgent real-time alert received on course. Stewards are asked to gather information from the jockey immediately about the start and the reason why it began so poorly. Betting analysts immediately contact the betting exchanges who agree to collaborate with the BHA under information sharing agreements we have in place. This is an important aspect that all racing jurisdictions should ensure they have in place. And again, it's a point that's noted through in the Integrity Handbook. Subsequent to the race day, the betting operator identified a number of accounts that had opposed Samovar in the match race. These accounts demonstrated potentially suspicious biases towards other horses ridden by Danny Brock. This, of course, then started to widen the scope of the investigation. A group of individuals were identified as persons of interest to the investigation due to their betting activities and their connection in those betting activities with other horses ridden by Danny Brock. The gamblers or persons of interest were identified and became central to the investigation and our understanding of what had gone on. They included an assistant trainer, a registered owner, and numerous other unregistered individuals who had been betting on the races involving Brock. The accounts of interest had all been placing bets on that day on Tricky Dicky. They had loaded their accounts the morning of the race, and the betting that they'd embarked on made up a majority of the market share. The accounts had also taken positions, significant positions, laying, so betting against or to lose, other rides of jockey Danny Brock's taken previously. In the Samovar race, the one we've just seen, however, the betting was quite extraordinary. The largest bet on two of the individuals of interest's betting exchange accounts was on Samovar's sole opponent, Tricky Dicky. Combined, three of the individuals involved in the alleged conspiracy took 51% of the profit on the race on the Betfair Sportsbook. Three of the individuals involved in the alleged conspiracy had generally displayed in the past in-running, laying and backing to produce no-lose situations, hedging effectively. However, this approach on this particular day in this race was ignored to support Samovar's opponent, Tricky Dicky, in the Southwell race. Interestingly, and you can see on the screen, that Samovar had a history of running over 5 furlong on the fibre sand at Southwell. And you can see that here, sectional time data analysis revealed that in addition to the very awkward start, Samovar covered the second furlong of the race in a time that was more than 1 second slower than on any of his previous 7 starts on that racecourse under those conditions. As I just touched on earlier, these investigations take time, and when individuals refuse to cooperate, this adds further to the challenge for regulators. Therefore, as the team expanded the investigation, further races were analysed retrospectively. These included rides on horses Mokolov and another horse, Resurrected, in order for the team, our investigative and bet monitoring team, to build a picture of behaviour of wrongdoing. A good example of this occurred some months later, in September 2019. The horse Resurrected, which appeared, the result of the race appeared on the previous screen, again had been ridden by Danny Brock, and it had once been owned by one of the alleged conspirators in the Samovar race. In this particular race at Chelmsford, it was now running in a new owner's name. As it happened, the name of his partner, the jockey's partner. It had shown no form in 3 runs to suggest the horse would be competitive, and it was carrying an official rating of 30. It was supported on this particular day at Chelmsford from 25 to 1 to 10 to 1, started at 10s as a starting price, and substantial winnings were made by the alleged co-conspirators in the Samovar race on this particular Brock ride. Oh, sorry. However, at that time, as the investigation was still developing and the nexus between Jockey Brock and the alleged co-conspirators was being analysed, the race day stewards identified, following this race at Chelmsford, that Brock had attached to his whip tightly bound elastic bands to the padded section of the Procush whip, and this can be observed, the red circle on the screen. Veterinary examination post-race revealed that the horse had marked up with considerable wheel marks, and as a consequence of this modification of the whip used in the winning ride. Brock, incidentally, was dealt with by the stewards for this offence in isolation and suspended for a period. And this all occurs as the investigation and analysis of multiple rides continues. The lack of cooperation from the alleged co-conspirators meant a greater reliance had to be placed on the betting evidence and analysis of the races and other information that had been obtained. That included computer sharing, so where the individuals had shared IP addresses, the horse ownership interests, the records of interview that had been taken before some refused to cooperate further, photographs that had been taken by investigators, the individual's social media activity, telephone records obtained from some of the persons of interest. This all built a picture of betting corruption, a conspiracy where market-sensitive information, inside information, was being shared by jockey Brock, and he was riding horses to accord with that information, either to win or lose in order to derive financial gain for him and these other individuals. This redacted association chart on the screen highlights the extent of the analysis undertaken to establish the various connections between all the individuals involved. In December 2022 and January last year, the independent judicial panel of the British Horse Racing Authority considered charges brought against several individuals involved in the alleged conspiracy, including jockey Danny Brock. You can see there from the comment of the final decision of the judicial panel, they found that there was persistent behaviour in breach of one of the most fundamental tenets of the sport. It involved cheating, not just the connections of the horses he rode, but also those who were on the wrong side of the bets in those races. It also indirectly cheated everyone involved in racing. He was charged with committing a fraudulent or corrupt practice in relation to racing by agreeing not to ride and then not riding a horse on its merits on 3 occasions from December 2018 through to September 2019, in the knowledge that others charged in the case would bet on the outcome. He was also charged with passing inside information that he would not ride the horses on their merits to these others. He was also charged with specific riding offences regarding his failure to run the horses on their merits and to ride to achieve the best possible placing. He was found to have intentionally failed to ride to achieve the best possible placing and to have done so for personal reward, in the knowledge that the horses had been laid to lose. He was found to have done so persistently and also to have passed inside information regarding those races, and was disqualified for a period of 15 years. Numerous other individuals were excluded from the sport for failing to cooperate with the investigation. These were unlicensed individuals. And importantly, the panel ordered that they not be permitted to make any future application to lift the exclusion order for a period of 15 years. And this exclusion order has the same effect of disqualification, prohibiting those individuals from participating in the sport or attending a racecourse. In terms of conclusion, this case establishes a clear precedent that direct contact between a jockey and those involved in a conspiracy is not required to prove a case like this. We built a circumstantial case in many ways because of the lack of participation by or cooperation by those involved. It established that there's enough to that indirect communications or connections between a jockey and bettors, particularly in a case built on extraordinary betting patterns and one particularly egregious ride. It illustrates the usefulness of identifying races in which the jockey is not alleged to have failed to ride a horse on its merits, but in which betting patterns suggest connections between bettors and the passing of inside information about the prospects of a horse. In this case, we'd been able to identify 3 corrupt rides and 6 additional rides where the bettors supported the horse and the jockey in question clearly rode the horse to win. Most importantly, this case also highlights yet again the importance of racing and sports regulators having professional resources, and I would advocate this for everybody in this room, in-house, to monitor and act on betting activities relevant to their participants and their sport. I appreciate that not everybody's going to have the resources to have those skills in-house, but work and collaborate with your colleagues from other racing jurisdictions and get support where you can. Further, it highlights the value of entering into information sharing agreements with betting operators to protect the integrity of the sport. That's to the benefit of the sport, the betting operator, and other bettors legitimately engaged in regulated markets. And of course, this particular case is talking about a situation that we were able to get to the bottom of because it happened within the regulated betting environment. And this afternoon we'll hear from Martin Purbrick about the challenges that the unregulated betting market poses for us. So finally, I'd like to take this opportunity to congratulate the IFHA Executive Council for having the foresight to prioritise the development of the IFHA Integrity Handbook as an incredibly useful resource for members to utilise further in strengthening the integrity of the sport. And I'd also like to extend a particular thanks to my colleagues and team members back in Britain who were involved in this lengthy and complex investigation to bring it to a conclusion. It's their skills and expertise that enable us to maintain the integrity of our sport. Thank you.
Good afternoon, everyone. Thank you very much for the invitation to join you today and to be able to speak about U.S. law enforcement priorities and the sports integrity landscape in the United States. I am pleased to be a partner at Steptoe. I am certain that it is not the reason that I've been invited here today. I previously was with the Department of Justice sitting in the United States Attorney's Office for the Southern District of New York, which sits in Manhattan, for a little over 10 years. And it's in that capacity that I had the opportunity to work with state regulators, with trainers across the country, and with a team of FBI agents in New York and around the United States on a sprawling investigation that led to some significant charges and some significant sentences in the world of doping and corruption in the U.S. horse racing world. What I'd like to do today is mostly talk about the United States from the perspective of criminal law enforcement in sports integrity, but I will start with a brief overview of the sort of state of play of the United States with respect to sports integrity. And the key takeaway is that there is an increase in interest, an increase in resources, and an increase in activity from an enforcement perspective in virtually every layer of the United States' multi-layered enforcement network. In the US, we have both the criminal and the regulatory regimes, federal and state regulators now, and prosecutors. On the federal side, there's recently the establishment of HISA, the Horse Racing Integrity and Safety Authority, has now brought a degree of uniformity and certainly an increased interest and drive towards integrity at the federal level. And as I'll be talking about in a moment, federal criminal law enforcement has also taken a significant interest in the field of sports integrity, both from the doping perspective, the gambling perspective, and others that we'll get into. But the same is true at the state level. And indeed, federal law enforcement in the criminal space and HISA on the regulatory space continue to cooperate with states across the country where racing remains economically vital to many states around the country. It is the case right now that there are many states that have opted in and are extremely cooperative with HISA. There are certain states that have purported to opt out. And indeed, as many things in the United States entail, there is protracted litigation right now involving fancy law firms and the U.S. Supreme Court potentially to determine exactly the scope and nature of HISA's authority. But to draw on a theme that Justice Clark mentioned earlier, the notion of not only instilling integrity as a virtue in itself, but being seen to embody and instill the virtue of integrity. HISA has had that effect both at the federal and at the state level at this point, with significant decreases in injuries and fatalities being transparent and open to observers. And meanwhile, certain of the objecting states continue to embody the opposite of that virtue with a lack of transparency. As I think HISA continues its work as the U.S. environment continues to take an interest in sports integrity, to Justice Clark's excellent point earlier, I think we will continue to see an increase in that kind of transparency and the results that come from a focus on sports integrity. The same is true in terms of private enterprise, and now thinking through some points that Brant made earlier with respect to sports betting. In the United States, again by virtue of a Supreme Court ruling a few years ago, sports betting and sports gambling has exploded as an industry, has exploded as a source of revenue for certain companies. Legal platforms have sprung up across horse racing, but also sports in general. And in part as a result of the enforcement actions that I'll talk about in a moment, in part as the result of obligations that are already in existence with respect to financial institutions, there is an increased interest in the United States among these platforms in building out robust anti-money laundering policies, in building out platforms, software, technology that can do the kinds of aberrant behavior screening that Brant was referring to earlier at scale. And I think that will also only continue in the midterm and long term in the United States as we see a similar and corresponding increased interest on the law enforcement and the regulatory side. At the University of Kentucky right now, you may see an example of internal investigation involving allegations of malfeasance in a testing lab. And as the direct result of some of the cases we'll talk about in a moment, a suite of compounding pharmacies focused on veterinary medicine have undertaken robust internal investigations. I think all of this is here to stay in the United States. But I'm going to turn most of my conversation today to federal criminal law enforcement. This is a pair of Crocs that was found in a search warrant involving Jorge Navarro. These were in my office for a number of years. I never got a chance to or desire to try them on. But Juice Man was Mr. Navarro's self-given nickname, a reference to the drugs that he habitually pumped into the horses under his control. This is a federal case, and again, to give some context here, in New York, we, at the U.S. Attorney's Office, we sit in Manhattan. Every case has to have a connection to New York in some capacity, but the scope and the reach of the federal law enforcement agencies in the United States is quite broad. And this case had touch points from every corner of the United States, from California to Florida, and indeed beyond in Canada, in Europe, in the UK, the Middle East, and elsewhere. The ability to compel information to be provided through documents, through interviews, et cetera, is a massive amount of power that the federal criminal prosecutors have, and it was brought to bear in this particular case in full force. The way in which this case really came to my office was through an organized crime squad with the FBI and through the unit within the prosecutor's office that generally focused on cross-border organized crime. And as a result, the tools that were brought to bear on the Navarro, Jason Service, and Seth Fishman investigations and others mirrored those of what you may envision as a typical organized crime, mafia-style case. We were able to engage in wiretaps, judicially authorized, for a period of 1 year over approximately half a dozen phones. There were email and electronic warrants issued for countless people over the course of the same 2-year period of the investigation. The use of informants obviously is key, just as others have talked about today, in terms of understanding the dynamics and what's happening behind the scenes of a given barn. But we also used an extensive amount of covert recordings using some of those informants, using some undercover officers, and indeed covert blood draws that were conducted through the course of the investigation in order to build out as large a case as possible and to put our arms around as large an enterprise as possible so as to have as broad and clear an effect as possible. On the covert blood draws, just one quick shout out to the notion of having good experts that's come up a few times. We benefited greatly through a very expeditious veterinarian who was extremely useful in the course of this investigation, who was willing to traipse through the woods and the swamps of rural New Jersey in order to sneak into a particular barn in the dead of night, draw a vial of blood from a horse that we had just heard on a wiretap to have been doped with Epigen, and then sneak back out in order to provide that blood for testing, and sure enough, we found what we suspected that we would find. In the course of the same investigation, this is a photograph of a blood builder, hence BB, that was found in massive quantities at a number of barns around the United States, and again was something that came up over the wiretaps again and again. It was striking to me in the conversations previously during this panel that the same problems from a legal perspective, sometimes a very specific level of abstraction, arose in jurisdiction after jurisdiction, and the same arose in the United States in extremely similar context. In the United States, there is no federal law that is specific to the doping of animals in sport. There are such laws at the state level, including criminal laws at the state level, but the federal level, there has never been a law, and even today there's not a specific law that targets doping of animals in sport. And so in building out this investigation, thinking through as a prosecutor, how can we approach this problem? How can we approach judges and explain to the judge what the criminal gravamen of the investigation is, and what the elements of a crime might be that would allow us to get the tools necessary to conduct the investigation, the judicially authorized searches, the wiretaps, et cetera. We had to think through where in the criminal code can we find a hook and find some purchase for this investigation. And we found two. The first was the broad use of the fraud statutes at the federal level. The notion was that there were false pretenses being used in order to take money from other people. The false pretense here being that a horse that showed up at a race was not doped in conformity with the state rules, when in fact it was doped and done so for the purpose of winning the race. That was a novel use of the fraud statute. There's not very much by way of law out there in our common law system from judges to describe exactly how this case might fit into that statute. But over and over again, I think the nature of the activity here resonated with the judges as falling within that statute. And it's important for a number of reasons. The main being, and again to draw on a theme that was mentioned earlier today, there is a significant disincentive from a financial perspective of using our fraud statutes because we can disgorge profits. We can take proceeds using that particular statute in a sometimes aggressive but certainly fulsome way. We conceived of the victims in multiple ways here. Personally, when speaking to the jury at the trial, the victim in my mind was often the animal, and thinking of this case as an animal abuse and animal welfare case was important for talking to a jury of 12 people. When talking to a judge about what the legal elements are, the victims that we conceived of were the betting public on the one hand, clean competitors, I think was another obvious choice, and racetracks and authorities that were attempting to run a clean and an integrity-focused race. The second bucket of laws that we drew on were general drug safety laws. And again, these are the sorts of things that tend to govern contamination of food or contamination of a batch of drugs. They're applicable generally to both humans and animals. And although they're usually focused on issues like sterility or the effectiveness of drugs and the development or their packaging, we use those same laws here to target false prescriptions or the entire lack of prescriptions for drugs that otherwise required a prescription, mislabeling and false information on the labels themselves. And we have some examples here. The TB7 on your right was in fact not for research and development and not for clinical trial use, but in fact was handed out to whoever wanted to pay for it in order to dope the horses. And the per se unsafe use of these drugs. The fact is that all of the drugs at issue in this case were being created essentially in somebody's back warehouse under circumstances with no controls for sterility, no controls for uniformity, and the notion that a trainer, even a trainer who was actively trying to get an illegal edge in a case, knew what was in the bottle was quite low. Again, some of the challenges raised to the case sound very much like the challenges that my colleagues across the world have been confronting as well. The first was the incantation over and over again by any number of defendants in this case that the fact that a drug was untestable must mean that it was also not doping, that it was legal precisely because it was not testing as a prohibited substance. Judges batted that argument away regularly, notwithstanding the fact that it was raised at virtually every stage of this investigation and ultimately at prosecution. There were challenges also to the notion that there were no victims or that victims couldn't be identified. This was important, again, from the perspective of trying to affix a dollar figure to the fraud and trying to think about how much money was lost and how much of a financial penalty should be imposed at the end of this case. And again, this was something that the U.S. Attorney's Office was able to overcome, able to argue to the judges that, in fact, there were tangible victims. And the fact that there are many, many such victims does not make that notion abstract. It just makes the fraud extremely broad. We faced arguments about, under the drug laws, regarding the concept of supplements, or what were sometimes referred to as nutraceuticals, which is a word that does not appear in the federal law. And the notion that those are things that are essentially unregulated because not specifically discussed in federal law with respect to animals. This, again, was a challenge throughout the case, but one that was overcome. In fact, the breadth of the misbranding and adulteration laws was plenty broad to cover all of these things. And the notion that slapping the word supplement on a bottle of homemade Epigen would somehow get you out of federal trouble was rejected again and again. The last issue that we faced and overcame again and again was the attempted use of a veterinary license as essentially a shield. The claim would be made again and again that a particular drug was being offered by a vet and thus was essentially prescribed specifically for the horse and not off-label, not adulterated. But what you saw in the patterns displayed in the email warrants and the patterns displayed in the wiretap were veterinarians who were acting as hired guns, who were not themselves acting as a vet, but who were acting at the direction of trainers or others to administer whatever drug the trainer or others wanted the vet to administer. The use of the veterinary license came up again and again and again and again. It was denied as a defense. And in fact, in the one case that actually went to trial in the Navarro case, it involved a veterinarian who made precisely this argument. But the overwhelming evidence in the case demonstrated that his veterinary license was essentially being used as a sham. All of these arguments were rejected, all of these challenges were overcome, and at the end of this investigation, there were significant penalties imposed, including jail time in one case up to 8 years, and millions and millions of dollars in restitution and forfeiture of funds that are now available for victims of this offense. There were over 30 trainers, veterinarians, drug manufacturers, and others who were convicted either through plea agreements or at trial. As I said, millions of dollars in restitution and forfeiture payment. And this became, I believe, a direct impetus in the ultimate passage of IFHA and pushing this forward on the regulatory side as well as on the criminal side. But the continued surge in interest in sports integrity continues today, although the Navarro, Service, and Fishman cases are virtually all resolved. We have seen still new cases arising out of that investigation, for one, but new investigations arising in different pockets of the United States, generally from different federal prosecution offices. U.S. compounding is one that involves a veterinary compounding company, essentially at scale, issuing prescription drugs with no prescriptions. Glover is a case that's working its way through the New York courts right now, also involving a compounding pharmacy. The Rodchenkov Anti-Doping Act was passed a few years ago. It focuses on essentially on Olympic doping or international sports. It's not a horse-specific statute, but it's another example of sports integrity being at the forefront both in Congress and in the executive branch and prosecutors. And indeed, my office at the Southern District of New York brought the first 2 such cases, criminal cases, under the Rodchenkov Act shortly after its passage, involving, again, doping by U.S. persons, doctors or pseudo-doctors, providing medication, blood builders, and others, other illegal prescriptions to track and field or athletics competitors at the Tokyo and other Olympics. As I mentioned earlier, I think there's a perception of increased enforcement and compliance in the private sector as well in the United States that we will continue to see as these public efforts continue apace. Racetracks, even individual trainers and owners are instilling compliance programs in a way that we believe is heretofore unprecedented. We see compliance programs essentially undertaking a proactive review of their data collection, their record keeping, and their liaisons with law enforcement if and when needed. We see a parallel increase in the scrutiny of sports gambling and the private sector's own scrutiny of its practices in the recent shift in the U.S. gambling landscape. There are sophisticated monitoring programs, some being built in-house by companies in the United States like FanDuel or DraftKings, and the use of the sort of sophisticated monitoring systems is becoming more of an expectation of normalcy, not something that's above and beyond, but something that is just basic good hygiene. That in turn is fueling continued criminal referrals. And there was I think a slide earlier that mentioned a few new charges in the United States involving sports gambling and insider information in the basketball context. That is a situation in which private enterprise doing its own screening and flagging problems for public officials who are at an all-time high of interest in these cases work together to get those cases over the line. It has been an absolute pleasure to present here today. I look forward to the Q&A, and thank you all again.
But I'd like to recall to the stage Mark Van Gestel, Cleaner Guy, Jamie Stair, and Brant Dunshay, please. Okay, very shortly I'll allow everyone in the audience to put the questions in. Let's just pop along the panel. And Mark, I'll start with you. You pointed out one of the significant things you did in the case that you referred to was the appointment of a retired judge, Mr. Mason, to the panel. Just tell us about the benefits of that particular appointment.
Is that working? Yeah, I think it's working, is it? Yes. Look, it was just in relation to, we had an official who had been involved in the case where tried to influence some witnesses to give evidence, and so it was important to have somebody on that particular panel who had less association with that particular case. So what we decided was that it would be good to have a judge of his standing, a retired judge of his standing, to provide some independence to the process. And essentially, really, it confirmed that racing did have good systems in place in terms of prosecuting and bringing cases forward. And essentially, Mr. Mason was able to validate a lot of our processes and ensure that we could continue on without having any major disruptions in terms of challenges to the constitution of the panel.
Cleaner, on the case that you referred to, one of the interesting aspects I think that struck a chord with a lot of people was the use of hair samples, obviously for racehorses in particular, and just the impact that you think that will have going forward and the accuracy behind using hair samples.
I'll caveat this with I am not a vet or a scientist. The hair samples were extremely beneficial for us because with the segmentation done, it could help us identify if you were dealing with a prolonged exposure, a once-off exposure to the substances involved. So no one matrix, as I've been regularly told, is the answer for anti-doping, but a use of all matrices in the right way. So you're looking for the right sample from the right horse at the right time. And hair has had a slow start in anti-doping. It's not widely used in human anti-doping, but we did have it approved, or the panel found against the challenge to it. And with the benefit of our experts who were able to give clear information as to the use of hair, how hair was taken, the process we had for taking hair in the sampling was also stood to that challenge. So I think hair will form part of our armoury, as with all aspects of it, and especially in integrity, there's no one thing that we can rely on, but it's putting all those processes in place, ensuring our rules were broad enough to cover hair as a matrix and how we dealt with that. So that helped us, but I do think, well, I won't say hair is the answer, and we might not see another case for quite a bit of time, but in relation to anabolic steroids and the incorporation of that into hair, it has really benefited us in dealing with that case.
Brant, on your particular topic, which I enjoyed your slide, which all pointed back to Danny Brock, but it involved a number of elements that obviously took quite a long time in piecing together. I mean, it seems, from a layman's point of view, quite a complex investigation that takes a degree of time in order to come up with that. What's the intelligence that's required to produce that case and that investigation?
It is challenging, and I touched on that point that these sorts of cases take time. One of the challenges for us in particular in Britain is that we're a member-based organisation. We don't have statutory powers to compel people to give evidence or participate if they're not licensed. In this case, 3 of the individuals were not licensed individuals. They were not bound by the rules, and so we could not compel them to cooperate with the investigation. So therefore, your investigation has to turn on the evidence that you can acquire through intelligence gathering, open source searching, and I touched on that. And it takes time for you to build that picture. And particularly if the case, many aspects of the case are actually somewhat circumstantial. So it's challenging to build a picture, but when you have the right resources, skills and expertise in-house, over time you can do that to create that picture of wrongdoing to satisfy a panel that breaches the rules have occurred.
A lot of recurring themes all the way through it. But one thing that you spoke about, Jamie, that was quite interesting, that I think is really important for integrity, is collaborating with external agencies. I think everyone has referred to that in everything they've had to say. Perhaps you could just enlighten us on how important that was in order for you to piece together your case and your investigation.
Oh, it was imperative for us in this particular set of circumstances because we were being thwarted at every angle that we tried to take ourselves. And you know, over years I've heard some people say that stewards and the like should have the same powers as police. I personally disagree with that. I don't think that's acceptable to the community that stewards would have that level of powers. But how you overcome that is having a good constructive working relationship with the people that do have the powers you require, and you make sure that legislation and law enables you to utilise those to satisfy the enforcement agencies that they can do what they want to do, and where there's matters that they can't progress but clear breaches of the rules of racing, that they're able to supply you with that information. And that's, you know, the point I was making. That's a very significant finding, that finding. And so you're able to attack it at all angles because you get to use the information that doesn't constitute a criminal offence. If there's other information that does constitute a criminal offence, once that prosecution's occurred, you then have access to the public record and all that information anyway. So it sort of seals the deal, if you like.
Andrew, we were chatting outside just a few minutes ago about some of the cases that we've heard about and how close some cases that haven't been constituted as criminal offences could potentially be. Obviously, you pursued that case yourself, the Navarro case, under those circumstances and under those details. How much of an impact do you think that has on the sport as a future deterrent, as a disincentive, as you mentioned?
Well, I think it certainly had an immediate impact in terms of clearing out quite a broad swath of bad actors across the U.S., both in thorough and standard bred, and had that sort of immediate effect. Going forward, I think it is very likely that people who previously thought that the cost of doing business, even illegal business, would be relatively low fines in state proceedings, now have to grapple with the notion that there will be not just full disgorgement, but potential imprisonment for willful violations of other people's rights.
I think, obviously, everybody else on the panel, you've all spoken about cases that you have in the past, you probably have done, and probably even considering some now, but you're cases that could potentially touch the boundaries of what constitutes a criminal case. Do you feel that would give you, as we said earlier, a better deterrent, give you more power, give you a chance to perhaps have that? I mean, Brian, when you talk about the Danny Brock case, that's very close to what could have ended him in jail.
Absolutely, and I was just chatting in the lunch break. I mean, for us, we have those sorts of cases come up from time to time, and you have to have, as Jamie touched on, relationships with the relevant authorities to ensure that if they have the power to initiate criminal investigations and proceedings, that they're prepared to do that. And often one of the challenges for us in a sporting context is that law enforcement authorities, other regulatory authorities don't necessarily have the resources available to be able to deliver what it might be that we would like them to deliver. And so often you have to package something up to them and hand it to them on a platter. In some of our cases, we refer these matters to the likes of the Gambling Commission, and unfortunately they don't necessarily end up as criminal proceedings.
Okay, I mean, I could carry on asking them questions, but this is an opportunity for anybody out there with a question for the panel. Just put your hand up, and we have got roving mics So if anybody wants to kick things off amongst the panel. Is that V? I would have had a bet on that.
Thank you very much, Rishi. This is to all the panel members, and I know it comes, the point is my colleague on my right says it's integrity at any cost. So the first question is, maybe starting with you, Mark, what's the cost to appeal, number one? And the follow-up question is, do you recover costs if they're unsuccessful? I think that's a very important question to us because we work on a tight budget. So how do you handle the cost of the appeal and do you recover cost? Thank you.
Well, firstly, dealing with the case that I presented today from my former position in New South Wales, I mean, the cost to appeal there was quite minimal. I think it was a $200 deposit that was paid. The next level was a $500 deposit. So, I mean, the cost to appeal is not all that exorbitant. So, in a way, it can encourage, you know, a number of appeals to be lodged just to test the waters to see whether or not that can occur. I mean, there's positives and negatives for a low appeal deposit. It encourages fairness and giving people opportunity to have procedural fairness, natural justice. But it can come at a cost sometimes in terms of having a large volume of appeals. In terms of cost recovery, it's not something that in my previous role or my current role that we've ever endeavoured to retain, but I mean, it would be open in a criminal jurisdiction to do that if necessary. And I know that the case that I presented with Dr. Matthews, costs were awarded to Racing New South Wales, so that was obviously something that was beneficial for them.
If I could just follow up on that, obviously the financial cost, but there's also the resources that you need. I mean, Clearly, you mentioned some big numbers on that Luke Comer case. Do you have the power of resource available to you to deal with all of that?
To be honest, no. You don't have a resource sitting there waiting to be used or to be redeployed specifically for that case. So everybody who was involved in the case had, for want of a better term, a day job. And racing had to continue. So we were working across what we have to do and keep going and managing the case at the same time. And when I said 182 booklets, there was a large portion of that was correspondence. And that was only the correspondence between the parties, not in between our legal teams. We did get awarded costs, and we do have the provision under our rules for costs to be awarded to the IHRB, but then recovering the costs can be another process within itself. So from a resource aspect, you are diverting people to cover the case and to deal with matters as they come up. And it does mean that you're balancing the ongoing priorities of the organisation. I will say in terms of cooperation, and one I forgot to mention in terms of BHA had done a study, an administration study, which related to methylphenidate and methyl testosterone, which also assisted us in dealing with the case. And by having access to that, it gave our scientists and veterinarians an ability to deal with the challenges that raise. But you don't necessarily have the resources there, and part of the reason the trainer involved is somebody who is extremely successful in his outside of racing life, has resources there, and that's one part of it you look at when you have the case. The other aspect was it was anabolic steroids in a hair matrix, and that's why I instructed counsel almost immediately and went to external, because we didn't have the capacity to deal with it. But even with that, the logistics, the general maintenance, managing correspondence, reviewing scientific reports all had to happen at the same time as horses had to be on the track, veterinarians had to be doing trot-ups, and I had to be running disciplinary cases.
So a lot to have to handle. Any other questions out there? Jim.
Brant, you mentioned the use of anonymous tip lines. Can you just tell us a little bit how that works with you and how frequently you hear tips?
Yeah, for us, it's effectively, we outsource that. It's run by the same group that run the Crime Stoppers call-in service. It provides information and intelligence to us in an anonymous fashion, but it also can direct people to, provide information and identify themselves so that we can further follow that up. on an annual basis. I think our intelligence database generally would receive somewhere between 2,500 to 3,500 entries a year of different sorts, not just from the reporting line, and all of that. The system is able to analyse that. It's assessed, and it helps us shift our resource allocation around current priorities. And so that's why we use that model. Just like Clina, touched on, resourcing is a challenge, and there are things you can do to get a greater return for your investment in terms of resources. And using systems like that enables us to filter the intelligence, identify themes and priorities, link cases, and then act on it. And during my presentation, that was one of the reasons I touched on the point for other racing nations that don't have the resources. Engage with those that do and can help you, and work together and collaborate, because the example of the Marks case, collaborating with Racing Victoria, that led to greater outcomes. So we should all take that on board.
Any more questions out there? Yes.
Hi, I'm Julie from BHA. I think one of the common denominators on all of your presentations was that they can take a long time to get from the initial intelligence through to a charge. And Andrew, I don't know whether there's any learnings from outside the sector, because that time gap also has an impact on trust with both the general public and also our participants. And just any thoughts of how we might expedite some of these long investigations?
So in the criminal context, I think that the question and the considerations are probably quite different. But there's a lot of thought that goes into the notion of putting essentially as many bad actors into a case as possible, while at the same time not taking 5 years to do the investigation. It would have been possible to charge any number of people in the Navarro suite of cases within weeks of the outset of the investigation. But the impact would have been, I think, drastically reduced. So that's the balance that we had there. But in terms of other sorts of rate limiting steps, testing was one, getting results back from labs internationally was the other. And I think actually folks up here as regulators may have a significant advantage as compared to criminal authorities in being able to quickly work across jurisdictions and across borders and with labs to get that information. For our side in the criminal world and sitting in the United States, there are significant hurdles that take time, that take money, that take advocacy to overcome foreign data privacy rules, to overcome a lack of correspondence between the criminal laws. So it may well be that in the regulatory space, your problems are different.
Question down the back, yes.
Thanks, Rishi. My name is Arnold Hyde, Racing Control Executive from South Africa. I think my question is probably best directed to Jamie with the case that Jamie presented on. And so many years had passed, and looking back at what the evidence showed. Would you agree, Jamie, that today is all about integrity? I think that is the fundamental that we're dealing with today, and everything that's being presented and being discussed. What would your feelings be on the integrity, and with that, with the level playing fields, as been alluded to in the previous presentation, the victim possibly being the horse with no voice? We try and protect the horse because we're the voice, as we say in South Africa, of the horse. How would you view the cost factor that V mentioned within very tight budgets of smaller racing jurisdictions, and trying to enhance integrity, apply integrity across the broad spectrum to all the participants, but bearing in mind at the back of your mind that there are tight budget constraints? Is it possible that you could bring in sayings as being pragmatic, pick your fights, or are you of the view that once you apply rules that you have to be consistent as the industry demands, that everyone's treated the same, and once you've opened up an inquiry, you can't look and say, this is actually going to cost a bit of money, now I need to turn a blind eye and lie down. How would you respond to that?
I'd say never turn a blind eye, Arnold. I think, look, integrity applies equally and the rules apply equally to all that sign up to it. Now, I mean, there's various integrity structures around, and there's a lot of rules or even laws that aren't designed to catch every person who breaks them, but they put in place a structure, a regulatory structure, that enables you to address the contravention when you become aware of it. And I mean, the simple analogy is there's a speed limit on every road, but that doesn't stop people speeding, and the police don't catch everyone that speeds. But when they do, they have the framework that they can address it. Costs are, I think, a concern for just about every jurisdiction these days. I think increasing costs. I mean, we talked about the level of involvement from lawyers in legal cases now, and I mean, often you hear the phrase, you won't like it, but it's become a lawyer's picnic, racing. And they do lawyer up everyone, and we talked earlier, Winfred mentioned about the increasing prize money, so they've got a bigger war chest to fight you, and traditionally people have matched arms, barrister for barrister, lawyer for lawyer, the like, so all those things come into place. But in relation to V's question, clearly no racing disciplinary tribunal in Australia is a cost jurisdiction. There are no cost jurisdictions. When you progress to the courts, well, that's a different matter if you go there. But so far as disciplinary hearings within racing, there's never any cost awards made whatsoever.
Unless there's a desperate burning desire to ask one more question. You sure? Go on. This is the last one.
Okay, very sure. I'm Ladislav Naď from the Jockey Club of the Czech Republic. I would like to ask about something else. It has been said that the cases, which were all very serious, take a long time to resolve. How do you manage the PR impact of these cases? Because we talked about social license of racing, and it happened in my country that there was a doping case which was fairly innocent. It was a contamination, but all the tabloid media, took the case and turned it against racing. So how do you do that? And are you able to communicate the positive impact of or positive result of your investigation that the culprits were punished?
I'm glad we took the question.
I think that was directed to me. Look, the impact on the industry, I think, was immediate and obvious. And what happened in the United States was a real surge in interest and effort and resources deployed towards integrity. These charges came down in March of 2020. The floodgates opened in terms of interest and effort within our legislative branches to push forward IFHA, to instill uniformity and consistency and integrity across a very disparate 50-state system. So I think the impact is measurable in that sense for sure. And with every story about a bad actor in this case, there were 20 stories about people who were trying to participate in clean sport, in clean competition, who were the victims of these people who were trying to get an edge.
Yes,
quickly, in terms
sure.
from a racing authority, you can't control the media or the information getting out, and especially once you start into parts of the hearing, information will get out, and it can be very frustrating. We have to go through the process. We don't want to risk prejudicing any part of our processes by making any comment. So until we're finished, we're not in position. Even when you finish your first instance, you're publishing, you're not making any comment on that because it's subject to appeal. So it can be frustrating. It can also be frustrating that when you publish the decision, while it might have a huge amount of detail in it and it might be quite a positive decision, that is not always communicated or picked up by others in the industry. So you do your best. Our comms team work very hard on that, and you get the information out there and you're dealing with it. So we publish our decisions on the website, and again, with gratitude to our chairs, you've written very detailed decisions and setting out the reasoning. So having those processes, having transparent decisions that are written and getting the information out there as to what worked is very positive. And we were lucky, especially in Ireland, we were extremely supported by HRI, who are our governing body, and dealt with it and supported us in that and in dealing with it. But the PR side, as much as you'd loved to be able to specify what and show what's there, you don't always win. But you just have to keep doing what we do, keep our relentless focus on integrity, on where our reputation or what our responsibility is, to ensure that we carry that out and do our function properly.
Rishi, I'll just flip it around also. You know, we're very good in racing, reactively dealing with these sorts of things. I think there's more we could do, and we're trying to do this in Britain, where we actually promote the good work, the resources we have in place, the tools we have available, you know, to the media, to participants, so that they get a greater understanding of what we have available and how we do what we do. That helps sell a good story and promote the integrity of the sport as well.
We could carry on with all these questions, but must draw this panel to a conclusion. I'm sure you'll all agree it has been thoroughly fascinating listening to Andrew Adams, Jamie Steer, Brant Dunshay, Cleaner Guy, and Mark Van Gestel.